above the compulsion of law in the exercise of those duties, end quote. Based on these principles, Chief Justice Marshall concluded that although discretionary acts are, quote, only politically examinable, end quote, the judiciary has the power to hear cases, quote, where a specific duty is assigned by law, end quote. Id at 166. Marbury thus makes clear that Article 3 courts may review certain kinds of official acts, including those that are legal in nature. The cases following Marbury confirm that we may review the president's actions when he is bound by law, including by federal criminal statutes. In Little v. Burham, the Supreme Court concluded that the president's order to a subordinate officer to seize American ships traveling to or from French ports violated the Non-Intercourse Act precisely because the Congress had acted to constrain the executive's discretion. 6 U.S. 2 Cranch 170, 177 Tac 79, 1804. Chief Justice Marshall observed that the President may have had the discretionary authority to order the seizure absent legislation, but had no discretion to violate the act. Id at 177 Tac 78. Similarly, in Kendall v. United States, ex rel. Stokes, the Supreme Court reviewed the official acts of the Postmaster General, the President's subordinate officer who derived his authority from the executive branch, because the civil case involved the violation of a statutory requirement. 37 U.S. 524, 612 Tac 13, 1838. To find a statutory violation unreviewable, the court held, quote, would be clothing the president with a power entirely to control the legislation of Congress and paralyze the administration of justice, end quote. Id at 613. Then, in Mississippi v. Johnson, the Supreme Court considered whether the state of Mississippi could sue President Andrew Johnson to enjoin him from enforcing the Reconstruction Acts, which the state alleged were unconstitutional. 71 U.S. 475, 497 Tac 98, 1866. The court concluded that it lacked jurisdiction to issue an injunction